Thank you, Mr. Fletcher. How are we supposed to evaluate that question and what the level at which coercion kicks in? I mean, if you're trying to coerce or get a particular result out of a media outlet, is it enough to say, if you don't do this, we're going to move your reporter's cubicle down the hall? Or how do you evaluate when it constitutes coercion in this context?
So let me start with, I think Bantam Books has been the lodestar for the lower courts that have mostly coalesced with some errors in application, like this case, around the idea of the question is it a threat or a statement that a reasonable person would understand, viewed objectively and in context, as an implicit or explicit threat of some adverse government action? Now, as to the cubicles question, I sort of don't know if there are some adverse government actions that are so trivial that they don't count. I guess I think something like that seems less likely to be a coercive threat. But in general, I think our position is if there's something that the government is saying that we're going to exercise government power in some way unless you change your speech in some way or stop distributing the speech of others, if it's reasonably understood as that sort of a threat, that's a First Amendment problem.
Well, but under Bantam Books, it presumably is in context what you're talking about, a reasonable person. I mean, if there is, as a regular basis, the kind of back and forth between a spokesman and a member of the media, what a reasonable person might view as coercive might not in that context. Maybe the press secretary yells on a regular basis, and if their volume increases enough, that might be viewed as coercion.
So I think that points up the context sensitivity. And I think, as is usually the case when the court says it's a reasonable person test, it's a reasonable person with knowledge of all the facts. And I think that would include the prior course of dealing between the relevant government official and the relevant recipient. I think here that really strongly reinforces the idea that there wasn't coercion. These were sophisticated parties. They routinely said no to the government. They were open about it. They didn't hesitate to do it. And when they said no to the government never engaged in any sort of retaliation. Instead, it engaged in more speech. Ultimately, the president and the press secretary and the surgeon general took to the bully pulpit. We just don't think that's coercive.
Thank you. Justice Thomas?
Mr. Fletcher, back to my point about coercion. Couldn't you simply do the censor someone or prevent other speech by others by agreeing with the platforms as opposed to coercing the platforms?
I guess I'm not sure what you mean by agreeing with the platforms.
Well, you just work together, said, look, we're right, they're wrong. Let's work together. We're on the same team. Let's work together to make sure that this misinformation doesn't gain sort of any following.
So I think as long as the platforms are exercising their own independent judgment, that's what the First Amendment protects. It says we don't want the government messing
So you're saying that the government can't censor by coordinating with private parties to exclude other speech?
I'm saying that when the government persuades a private party not to distribute or promote someone else's speech, that's not censorship. That's persuading a private party to do something that they're lawfully entitled to do. And there are lots of contexts where government officials can persuade private parties to do things that the officials couldn't do directly. So, for example, recently after the October 7th attacks in Israel, a number of public officials called on colleges and universities to do more about anti-Semitic hate speech on campus. I'm not sure, and I doubt that the government could mandate those sorts of changes in enforcement or policy, but public officials can call for those changes. The government can encourage parents to monitor their children's cell phone usage or internet companies to watch out for child pornography on their platforms, even if the Fourth Amendment would prevent the government from doing that directly. All of those are contexts where the government can persuade a private party to do something that the private party is lawfully entitled to do. And we think that's what the government is doing when it's saying to these platforms, your platforms and your algorithms and the way that you're presenting information is causing harm, and we think you should stop. And the platforms are.
So you really don't see any difference between the government coordinating with the platforms to exclude other speech and persuading the platforms to do this, to not engage or permit other speech?
I guess I'm not seeing it, and I think that what happened here was definitely on the, if you do think there's a difference between those two things, I guess my argument here would be that what happened is on the persuasion side of the line, because you do see that back and forth of the platforms throughout the process saying no repeatedly when they disagree with what the government is asking them to do. And I think that that tells you that what was happening here is what the First Amendment protects, which is private speakers making independent judgment, informed by, maybe even influenced by the government.
So there's no difference between the platforms meeting and working out an arrangement not to permit certain speech, and the platforms working with the government to do the exact same thing. There's no difference.
Well, I think if the platforms entered into some agreement amongst themselves, that might raise issues under different provisions of the law. The modest point I'm making is just that the government doesn't violate the First Amendment when it persuades a speaker to not distribute speech by someone else. That's Penthouse versus Meese, Judge Silberman's opinion there. That's what happens when the White House press secretary calls up the New York Times and says that was a bad op-ed, you shouldn't run op-eds like that anymore. I think that's commonplace.